Hello and welcome to episode number 153 for the National Land Podcast. My name is Mac Christian and I am the host for this podcast as well as the Chief Marketing Officer for National Land Realty. Now today we're talking about probate. And probate can either be a problem or it can be a solution or it can just be a piece of the puzzle depending on how you develop your estate plan and inheritance for land. Now today talking about these topics are Wayne Dunson, who is a National Land Realty agent in West Texas, and Tiffany Lashmet, who is an ag law professor and extension specialist at Texas A&M University. She is an esteemed guest for this show. This is her second time on, absolute expert on any topic involving land. So we'll be talking in depth about probate, about how you can work with it or against it or avoid it. Now, sit back and enjoy as we cover this topic. And we are live. I'm sitting here with Wayne Dunson. Wayne Dunson is one of our brokers out of our West Texas office. And I have Tiffany Lashmet. Tiffany Lashmet is professor and extension. I don't know. Was that part of the promotion? Is the expansion part of it? No. The professor and extension specialist of agricultural law at Texas A&M University. And so when I like to say that I like to get people smarter than me on this podcast, that's today. So today we're talking about probate, and it's something that really matters to landowners. And we have an aging population of landowners. That's no mystery. We're looking at the largest handover of riches ever in the history of our country, because we have a lot of people who hold investments, who hold land, who hold all kinds of things. And that population is aging. And by nature of that aging, things are getting handed off to younger generations, or as what we're talking about today, going into probate. So, I feel like jumping right in. Tiffany, tell us about your background, because, we were talking beforehand, and you just got a raise. You just got promoted at Texas A&M University. You went from brain trust to certifiable brain trust at Texas A&M. Tell us a little bit about your background and sort of, how did you get to where you are right now?
Yeah, sure. Well, thank you guys for having me back on the podcast. It's always fun to come on and chat. So I grew up on a family farm and ranch operation in eastern New Mexico, always interested in agriculture and knew that's what I wanted to do as a career. Ended up going to college and graduating from Oklahoma State University. And after that, I went to the University of New Mexico for law school. And then I landed this job at A&M about 12 years ago. And it really lets me kind of put my interests for agriculture and the law together. And so in my role here at A&M, I travel the state doing educational outreach to landowners and ag producers about legal issues that can impact them. So obviously estate planning, things like fence law and water law and property taxes, a pretty wide variety of topics that I get to work on, but it's a lot of fun.
Awesome. And Wayne, you've been on this. Have we lost count? I think. Oh, and if you're watching this on YouTube, yes, Wayne and I do coordinate our shirts. I called him up beforehand, made sure he had the blue checkers. We're matching. But no, Wayne, you've been on here a lot of times. But in case a listener is new, tell us a little bit about your background, how you got into land real estate.
And I'll be sure to get Tiffany the note on the pattern for the shirt next time.
We got to make sure to include the guest next time. Tiffany, I'd really appreciate it if you wear the blue checkers next time.
I would have been on board.
No, so I don't have as good a 60-second commercial as Tiffany has. It's a good one. So I'm the managing broker for the West Texas office for National Land Realty. Spent some time in the ag world. I got my master's degree in animal science at Angelo State University, and started out in the ag field, worked for Natural Resource Conservation Service as a range specialist, and spent some time in West Texas. And I went down to the coastal prairie and did everything from root plowing to burning. I had a lot of fun doing that. Ended up transitioning full-time into real estate in 2008, and then came on board with National Land in 2021 because I was really missing the outdoors in some kind of a bad way. And this was a way for me to join my passion with my paycheck. So now I get to go help people do things on land and do it for a living. So it's a lot of fun.
Excellent. Thank you, Wayne. And so, let's jump into probate. So we're talking about estate planning. And I think, everybody talks about wills or getting a will. And most people that we know talk about, yeah, I need to do that. And that seems to be a trend. And I think it's probably not a trend that's going to change anytime soon. So let's go with 101 level. Tiffany, if you could just tell us what exactly is probate for anybody that doesn't know.
Yeah, for sure. So kind of high level, what probate is, it's just the process of getting assets out of the person who's passed away, out of their name into the heir's name, right? Which sounds pretty simple. So if somebody dies and they have a will and they say, I leave my house to my children, probate would be the actual process where we actually get the ownership of that house changed from mom to the children. It's a really important step in the process, though, because that may sound simple, but failing to get that probated can really result in some complicated issues for heirs down the road. So, like I say, big picture, it's just that step of transferring those assets to the heirs.
And most of the time when we're talking about probate, and this is outside of my wheelhouse, so I'm just making this is coming out of my pocket, so you get to correct me all the way. But because I'm assuming there's other types, like anything that is the implementation phase is considered kind of a probate thing, but usually what we're talking about is it's a will, but will doesn't really have execution, and the execution of the will costs money. Or if you don't have a will, then there needs to be a little more work done because there's state laws that dictate how those things go. But probate is the execution of the objectives in the will or the not will. And that's usually done by state sanctioned attorneys, and those people need paid. And so there's a little bit of money that comes out of the inheritance that goes to pay probate, right? Is that kind of...
Yeah, typically that would be right. And so probate can come into play whether someone dies with a will or without.
Yes.
So that's important to know. The complexity of the probate and the expense of the probate depends on if you died with a will or not. So if you want to save money, die with a will, because the probate process takes longer. It's going to be far more expensive if you don't have one. So that's first thing. Whether someone dies with a will or not, probate may come into play. And like I say, it really is just like you said, kind of executing what the will says to do, right? The will says, I leave the house to my kids. Well, legally, we have to make that transfer, right? The will itself doesn't do that. So instead, you go through the probate process to get someone appointed who has the authority to act on behalf of the estate and actually sign the deed that would deed that property over to the heirs. So it's really like you said, kind of the execution arm of this process.
And that's something that I feel like is really, really important to note, is that not having a will is more expensive for the heirs. Now, if your children are a pack of jackals and you didn't really like your spouse to begin with anyways, not using a will could be a great way to watch all them argue it out, right? And it's going to cost them a lot of money. If that's how you're leaving this world, more power to you.
If that's our goal, that's your path. Yeah, that's right. That's right. For most of us, right, that sounds like a nightmare. And so I always tell people, and you're right. I mean, Mac, you said this and you're exactly right. If you don't have a will, it really is the state legislature who decides where your assets go, right? Because every state has something called intestate statutes. And they're basically a formula that the legislature has written that tells where someone's assets go when they die without a will. It seems crazy to me that we're going to trust the guys in Texas, so the guys in Austin, to decide where my assets are going to go, right? I am too much of a control freak for that. That's not going to surprise you, right? So I want to be the one who makes those decisions. And so having a will, like I say, lets you have the control over where those assets are going to go, saves you money in the long run. And a lot of times it really does avoid arguments and ongoing difficulties in the future.
Yeah, I like to talk about, because, a lot of people don't want to go through making a will or a trust or whatever it is because they don't want to talk to lawyers, right? Because that's always the thing. It's I don't want to talk to lawyers. I don't want to pay a lawyer fee.
Right.
That's one of the things that comes into play. But then it's that's discounting how many more you're going to have to talk to. Or actually, let's be real. You're not talking to any. The people who are still living are going to be talking to all of them and paying them. And so one of those things, but there's a big barrier there. Like Wayne, you've worked with a lot of landowners. How often do you go in and talk to people that just never set this stuff up?
More often than I would care to admit. It's wild. And I had mentioned this before we started recording. I run into it fairly often where there was a will, but they chose not to probate it because they didn't want to pay. But what they don't understand is that,
or what they found out later.
Yeah. So then they find out that if they can't direct where the assets, the money from the sale of a property, they can't tell it where it's going to go because the bloodline dictates it goes here. And if they'd have probated the will, it would go to where they wanted it to go. Or what they found agreeable. If for instance, we had one where she didn't want her stepson. I guess there was bad blood there. I don't want any of this to go to the stepson. Well, the only way to avoid that was to probate. I mean, but it's just really, I never have understood why they choose not to probate when there is a will there, unless they see what's in it and don't want that to happen, I suppose. But that's still crazy because then you're going to still have to unravel all of that business.
Well, and that's what I was going to say is, the problem is eventually this is going to come to a head. Right. And so maybe it's not today, maybe it's not a decade from now, but eventually someone's going to need to buy or sell or do something with that property. And it's still going to be in dead grandma's name. Right. And at some point you can kick the can down the road for a while, but at some point you're going to have to get this sorted out. And the longer you wait, the more complicated that is to do. Right. I mean, you'll see some situations, and a lot of times these ones don't have a will to probate, but where someone dies, they don't even go through the intestate probate process, right? And we end up with what's called heirs property. And maybe now we have 32 heirs that own 1/32 of this property, and they're never going to be able to get that sorted out. You know what I mean? So it only gets more complicated the longer you wait to do something to get, whether it's a probate or there are other alternatives you can use sometimes that are simpler, but you got to do something to get that asset transferred to the new owner.
Well, it's like work boot economics, right? So there was an old economic study done on workers' boots, and really well-made steel-toed work boots, like industrial level boots, like those are expensive. They can be anywhere from like $400 to $600 for a pair of boots. And a lot of workers don't want to go pay that. So they go buy a really cheap and affordable pair of work boots, but those are made cheaply. And if you run the economic horizon of that purchase, that initial purchase of paying $600 versus, $30 for I'm not going to use a brand name because somebody's going to throw something at me because somebody's going to love that brand name, but we'll say cheaper work boots. What ends up happening on like a 5-year horizon is you're spending like double the amount over that 5 years because your boots break all the time. You got to go get new boots. This is sort of a similar thing where you don't want to pay that upfront cost because there's an expense associated with doing things right. But by not going ahead and doing that in the long run, you end up paying a lot more to fix all the crap that you should have fixed up front. Like that's the kind of the basis that people run into here, right? Is like, I don't want to shell out $500. Like, oh, great. Then now your heirs are going to shell out $3,000.
Yeah, no, you're exactly right. And the other thing I'll tell you, and we didn't say this at the beginning, we probably should, this differs from state to state, right? The details, the complexity of the probate process, that all differs state to state. And so I'll give you an example. Here in Texas, I'm not going to tell you that anybody really enjoys having to do probate, but it's not super cumbersome, right? It's doable. It's something that most estates can afford to handle, et cetera. There are other states where you need to figure out something before you die, whether it's a trust or transfer on death deeds, whatever you have to do to avoid probate because it's so cumbersome and so expensive and so difficult. So, the need to avoid probate with certain tools before somebody dies may differ depending on what state you're in, just because the details and the process can differ. I promise you, though, no matter what state you're in, having a will executed validly before you die will save your heirs time and money.
And probably eliminate fights. Well, okay, so let's kind of go into this stuff a little bit, like from this side of things too. So one important distinction is that probate happens with wills and without wills. So a lot of people say, oh, I don't want to go through probate. Like, too bad you have a will, you're still going through probate. But it just takes less time, therefore less money, right? Is that kind of...
Yes. Yeah, that's exactly right. So two things. It takes less time and less money. it also lets you have more of a say in where your assets go, right? Again, because you get to choose in the will, the state chooses for you without one.
And then within that, like you have, because your 3 levels are basically no will, and then trust. Is that kind of the hierarchy?
Not exactly. So if you've got for probate, you've got will and no will. And either way, those likely are going to need to be probated, or you're going to need to use some alternative to probate in that process. A trust is interesting. And actually, one of the real benefits of a trust is they can allow you to completely avoid probate.
Mm-hmm.
So if we're talking about tools that we can use to avoid having to probate a will, you can use a trust. That's one way to do that. So I would put trust kind of in a different bucket,
of
as a separate tool, because it gets handled outside the probate process.
I got you. Yeah. And that's makes sense. Mentally, I have it sort of in a hierarchy, because it's like you have no one gets to say except for the state. And then you can say, but it can be contested. People can argue in court. You can always contest a will. You're still going through probate. Then you have trust, where it's like no one gets to argue with anything. And this is going to happen no matter what anybody's opinion is. And this is how it works. And there you go.
Yeah. I like to say it really does. A lot of times it'll let you avoid that probate process altogether. Right. So when you see folks that are setting up like a living trust, a lot of times the goal or the rationale behind that is to avoid probate.
Yes. Right. But we're talking about probate today, so I won't go into trusts, and I won't put you on the spot for that. Let's talk about sort of what, you talked about formulas with states with probate. And is there a sort of I can't put you on the spot and ask about if there's any uniformity because it's from state to state, but let's go into Texas. How is Texas set up? And then somebody listening could probably apply that with their own kind of logical reasoning on how that relates.
Yeah. So every state's got, like I said, it's called the intestacy statutes. You can just Google your state intestacy statute. And what you're going to find is a law, right? It's a statute that's written out that sets up this formula. They're all fairly similar in organization. The fractions can differ though. So I'll give you an example. So for example, you might have a state that says if somebody dies and they are married with no children. In Texas, if that happens, the formula says that the spouse gets all of the community property, and the real property, separate real property, is divided between the spouse and the parent half and half. Another state might do that, 1/4, 3/4. Or another state might not divide it between real property and personal property. They might do it community property versus separate property. So they can look different, but each state's going to have a formula. The problem with the formulas, right, is they're one size fits all. No family is one size fits all. And a lot of times you end up with joint ownership between folks that you may not have ever wanted to be joint owners in anything. Yeah.
So Wayne, you just talked about a couple case studies, and I don't want you, I want to protect the names to protect the innocent and all that, but you have experienced exactly what we just talked about. And I think it's always good to bring up examples.
Sure. So, and I wanted to, I'm going to bring up a new one that
yes.
I want to pick Tiffany's brain on, because I don't understand the process on this, and I'm dealing with the probate attorney on that right now. But one of them that I brought up, and this is my favorite one of all time. It was horrible for the client of mine that went through this. This has been many, many years ago, but this is a classic lesson of why it's important. If you want to be able to control what happens with your assets post death, you need to have something in place. And in this case, a gentleman and his wife, they own property together, been married for over 30 years. She passes away. She had no will, so she died intestate. Mm-hmm. And so he decides he's going to sell this home. And in the process of going through that, he finds out that his wife had previously been married and had children in another state, it never knew existed. And it took us a year. So he had to pay a law firm a year to track down these 3 children and get them all to sign off on the sale of this property. So we have a year tied up in this. Plus he has all the legal fees. And then ultimately, one of those children from her previous relationship that he never knew existed took a cut of the mother's proceeds. And that was the only way he could move forward with the sale. There was no other way to legally sell his home. And so they took a big chunk of that sale, and he never met the kid. It was an unbelievable deal. Now that's pretty heartbreaking. And I felt really bad for that guy. That was his retirement nest egg. And this unknown kid took a piece of it. But what if the kid hadn't agreed to that? There's so many weird things that can happen when it comes to this. And we're talking about small stuff. I'm looking at a ranch right now where there's I think 6 owners right now. And one of them has this rat's nest of stuff that we can't seem to uncomplicate. And we don't know how he came to own it. We can't find that piece of the puzzle. So there's trustees over estates on pieces of their heirs that did it the right way. And then we have this one that just totally, it's like, we don't know how this guy came to own it. You can't find it anywhere. There's no probate. There's no wills. There's no nothing. And he's like, well, can I just take $5,000 for my share and you can just have it? And I'm like, no, because that's worthless. Like, who's going to buy that? So now we're looking at potentially the rest of the family selling about 86% ownership of this property. Now there is mineral rights available on this, so we might get it done in the county where it's located. And then this other dude, what they'll end up doing, and we see this, it's not my first rodeo with this kind of stuff. They'll take him to court for what's that called?
Partition.
Yeah, partition suit. And they'll just cut out. He'll end up with 40 acres that he doesn't even know. He doesn't own totally, kind of. Can't do anything with it, but he's paying taxes on it because he can't clear title. And somebody else will buy the rest because of the mineral rights. And it'll be heavily discounted. I mean, like 25% of value max, probably. It's just unbelievable. So if you want to leave your family a legacy or not saddle kids or your spouse with this like jigsaw puzzle, it's just and it's hard. It's really a heart-wrenching deal for families when they have to go through this kind of stuff.
Well, and I think that's the perfect example too, Wayne. Like, you think about in that scenario, had that woman just had a will, right? Had she just had a will that says, I leave everything to my husband, all this is out the window because everything would have gone to the husband. We wouldn't have been in those intestate statutes where they go looking around to make sure you don't have secret children, right? Like,
yeah,
that could have all been avoided.
Yep.
Well,
That's
and
right.
I would
have totally ended that whole saga right there.
Yeah.
And I would even throw this grenade back the other way because one of my favorite stories is not good, but it's funny in a dark way. But there was an outfit out here where gentleman started getting memory issues, and like drop of a hat, his wife was going to throw him in a center, and he didn't want to be. And I don't think that either one of them ever really liked each other. So he went in and was just like, I write everything out of her name and into my, but he got to dictate what he owned, how he owned it, and who it went to. And he basically got his revenge from the grave. It's dark. It's not nice, but it's like he got to call his shots. This is how you do it.
Yeah. Yeah.
Well, you had mentioned that earlier, Mac, about if you had it's just a horrible group of kids and whatever, and you just want to leave everything unprobate or no will and let them fight it out. But the other end of that is, and you see this where they're like, they just donate it to their church.
Yes.
Or to a hospital or whatever. But again, if you don't have kids or you don't have, like, that's another alternative is you can still put in the will that I'm going to gift this to my university or to a hospital or a nonprofit. But it's got to be directed or you get no say. I mean, that's the problem with that.
That's right. And the other thing to think about, if you're talking about gifting like that, a lot of times that is a tool that they use if somebody has a real high value estate that might be going to result in estate tax liability. One tool to avoid the estate tax is you don't pay estate tax on assets that are donated to a charity. So if you wanted to leave that to the church or the university or whatever, sometimes you'll see folks use that as a tool But you're exactly right. You have to do that ahead of time, right? The state is never going to let that be where your assets go if you die without a will. We haven't said this, but another important thing, in Texas, your will can be handwritten or typewritten. We don't recognize a verbal will. So you can't tell somebody, I want to leave everything to Texas A&M. That doesn't do any good, right? The verbal is not going to be seen as legally valid.
Does that have to be notarized?
So in Texas, if you have a handwritten will, it has to be completely in your handwriting and signed. Doesn't have to be notarized, does not have to be witnessed. For a typewritten will, it's got to be all typed out and you have to sign it in front of 2 witnesses. Does not have to be notarized. Now, this should go without saying, but there's about a case a week where people do this wrong. The witnesses should be neutral. Do not go into your will and say, I leave everything to my favorite kid, and then guess who I'm going to have witness the will? The favorite kid. I swear to you, once a week, there's a case on this, and it's like, what? The bank teller would have done this for you for free, so.
Yeah, they were sitting at the hospital while they're heavily under, sedation meds, and they're like, here, you tell everybody I'm getting it all. Yeah.
Yes.
Like, ironically, little Billy was the favorite kid, and it just so happens to match little Billy's handwriting.
Who knew? Yeah, it's just people. Yeah. So watch who the witnesses are.
And I know we said we weren't going to get off into this, but I want to make a mention of this because it was important, and I see it a ton in the land in. Of course, you had mentioned the trust. Obviously, a huge vehicle for people to move land into, and like for farm and ranch stuff, it's a big thing. Like, right, we're going to put this into a trust, and everybody's got ownership interest or whatever. That's handy. But another one that we see here a lot in West Texas, especially where we're heavy in oil and gas, is families will sever the mineral estate, sell the surface, put the mineral estate into like a trust or something, and they operate that like a business, but there's never a concern. And so, like, if I go to sell a piece of property, just was at one on Sunday. It's an incredible place, and they've got mineral rights that go back to forever. Don't run into that a lot. I mean, this place has like stone livestock working facilities, like stacked stone from the 1800s. Like,
Oh,
this has been in their family for a long time. Anyway, it's been split up enough amongst the family members that they've decided they better sell now, right, before it gets divided up anymore. And they don't have the mineral rights in a trust, so we're having to reserve them as part of the sale, right, to keep that. But a lot of times we run into that where they don't want to stress over it, or they operate that like a separate entity. So they'll put their mineral estate into a trust, and now you don't even have to worry about that end of it. And I think that's smart from a business management standpoint. If you've actually got income derived from your mineral estate, of course now, and I think you may have posted something about it, even with produced water, who owns that? Like, holy cow, there's so much stuff that goes on with that now. I'm not trying to get too far off track, but I want to throw that out there for anybody that's listening, especially in West Texas or areas that have mineral rights or whatever. I'm sure that could probably apply to a lot of things. Tiffany can probably expand on that, but I want to throw that out there because there's other ways. I mean, obviously with a probate, you can pass all that on, mineral estate and all of it. I mean, you don't have to sever it or do whatever. But I just wanted to toss that one out there just for people that are listening.
Yeah, I think that's important. And like I said, a trust can be a great tool that lets you go ahead and get those assets passed from one generation to the next, right, within the trust, and avoid probate. So that's tool. There's things like LLCs that can be great tools. At least in Texas, we've got something called a transfer on death deed for property. So if you own land, you can do a transfer on death deed. And when you die, all they're going to have is a death certificate, and bam, it's transferred. You don't have to go through probate. So there
Is that
are
the ladybird deed?
Two different things. So there's actually a ladybird deed, which functionally works a little different, but has basically the same results. But we also have now a transfer on death deed. Okay. Those are newer. They've been around for maybe 10 years. There's a statute on them. Oh. But those can be great tools as well. So I guess that's the point, is if you don't want to have to probate, and if you're somebody who's like, we got to avoid that, there's lots of tools to do that. Do it before you die, right? Like, there are plenty of options that'll let you avoid probate if that's a goal that's important to you.
I feel like you see a lot of hesitancy. Watson, I brought up Dateline earlier. Probably too many Datelines out there, but to try to get someone to commit that when I die, you get this place. Like, I'm going to tell you right now, this is going to be yours. Not the same as, say, a remainder life estate where they get to basically give it away, but they get to stay on it till they pass. But that due on death type deal, it's like, I don't know. You got to be really trusting because, I mean, they know this land's going to be theirs if you just randomly drink too much antifreeze. I mean,
so interestingly, on the transfer on death deeds, at least in Texas, again, these can differ by state, and not all states have them, I don't think. But in Texas, the way a transfer on death deed gets written, one thing that's important to know is it's always revocable.
Oh, okay.
So we'll tell folks this a lot, right? Like, you can go record that deed. You do have to go record it in the deed records at the courthouse. But one benefit is you maintain all the control. So you can sell that property, mortgage that property, whatever you want to do. And if your kid makes you mad or tries to slip you the antifreeze, you can go change it, right? You can yank that back tomorrow. And so that does still leave folks with quite a bit of control, which can be a useful tool.
When you were first starting on that, I had something pictured in my head of like, I know I'm headed to the pearly gates, but if you help me, you get nothing.
Right. Yes.
I mean, if you think about it, it is kind of a morbid topic to talk about.
Like a don't kill me clause. Yeah.
Yeah. It's hard to discuss. I don't think I don't feel real comfortable talking about it, even with my family. I'm like, I set it up. I don't care what you do, but I don't want to have to fight with family. I don't care if I get 2 thimbles, put them in my name. Like, I don't want to have to argue about it in court. Like, that's horrible.
No. And Wayne, I mean, listen, you're just a man from West Texas. So like, that's just, it's in your nature, right? That's the nature of all the farmers and ranchers I work with, right? Do you think any of them are like, I think what we should do is sit down and have like a family discussion about the future and our feelings and our legacy? It's a nightmare trying to get them to do that, right?
Yeah.
So it's not fun. It's not enjoyable. But I always try to tell folks, look, I know it's uncomfortable, but if that's what it takes to make sure that this family, especially when we're dealing with like intergenerational family farms and ranches, right? If it takes a couple of uncomfortable conversations to get this thing to keep going down the road, we're just going to have to suck it up. You know what I mean? But it is hard to get folks on board because it is not enjoyable.
Yeah. Well, and I can see it being really even more weird when you got a lot of siblings. Like, does everybody feel like, well, I took care of mom more when she was sick? I hear that one a lot.
Yeah.
I was the one that did everything. I'm the peon. I did everything. Why should the other whoever family brothers and sisters get squat because I changed grandma's diapers? Or, like, that's nasty, right. But whatever. I just ran into this the other day where when the brother left, the other brother was like, he's the golden boy. Mom gave him everything, and I did everything for mom, and I'm fixing to go pick her up at the home. And he's she already gave him this house and this land, and and I mean, he was really bitter about it. And I get it, I guess, but I was just like, I don't know the backstory on these 2 dudes, but that was awkward.
Yeah.
I feel like you just described every family ever.
That's it. It really is. And let me give you the ag version of this, right? This is a super common issue that folks really have to think through. If you've got an on-farm heir and an off-farm heir, right? Maybe it's not taking care of grandma, but it's, one sibling moved to the big city and has lived there being a stockbroker his whole career. The other one stayed at home at the farm and kept this place running and growing and was feeding cows and planting cotton and whatever. And when the parents die, what are they going to do? And that's where, again, there's not a right or wrong. It's the parents' decision to make. But I think there really are a lot of factors that have to go into that. And folks have to really weigh the idea of that sweat equity, right? When they figure out how they want to divide that up. And the other piece of that you have to really think about is financially. A lot of times that what they'll do is they'll leave it half and half, right? Joint interest owners. And we'll think, well, the on-farm brother can buy out the kid in town. With what, right? All the assets are tied up in the land. And if you sell the land, you can't run the farm. I mean, so that's kind of the ag version of that exact same scenario where you've got people who have done different things and look at this different ways.
Yeah, I was going to say in those situations, getting people to realize like you're going to leave this land because you think that that's your wealth, but only one kid can run the land. Like maybe there's goods or something like that, or savings that you have because it can offset the wealth that you're not handing the other children to offset the land that you're giving the one that works. Getting people to come to terms with those things. Like my family had my great grandpa and my grandpa built a feed mill together. And so then grandpa worked it and all my uncles grew up working in it. My mom grew up working in it. Then you got to my generation, my cousins didn't, but I got shipped off every summer to work in it. And then by the time we all grow up, there's only one uncle left working it with grandpa. Luckily, they had that stuff structured because it could have been really easy for like all the uncles to say, this is all of ours, while one uncle was the only one that worked this feed mill. And it's like, thankfully this stuff was all worked out, but it's really easy for that to go sideways because then everybody gets an opinion. And man, you get a family in a room with somebody who's passed and everybody has an opinion, and you have a family that won't talk for 20 years. Yeah,
that's right. And I mean, I don't mean to keep going back to this, but like in that exact scenario, right? The intestate statutes don't care about any of that. They don't care that your uncle invested his whole life there. They're going to leave it equally to all the kids. Right. So yeah, it really, like I say, it's uncomfortable. It's not fun to have these conversations. It saves family businesses. It saves family land. It saves family legacies when you do it.
Yeah. From the land side of things, when I meet with somebody and he tells me that he's bought out all his siblings, I'm just like, oh, thank the Lord. Because you every now and then you get lucky and there is a successful sibling that's done well. And whether they believe it's fair or not, they go ahead and buy out their siblings just to own it outright. And not only does that make it easier from a sales perspective, because now I'm dealing with one seller and we don't have a whole bunch of other people involved, but it simplifies because you have one decision maker, and I'm not dealing with an entire family that's got, you said that, Mac, opinions. They've got opinions. So if we do get to the point that we're selling, but they all own undivided interest, they all get a say in it, and man, that can just really get difficult to deal with.
That's one to call out to every single landowner that could be listening to this. If you are leaving your land to multiple children, one, those kids are going to fight. There's like, you could break up your entire family by just introducing this without dictating how it's going to go, because they're going to fight. And if you have to sell that land, there's not a professional on this planet that wants to work with you. You might think that you have the best brothers and sisters on the planet, but behind closed doors, nobody wants to, because you're going to have that. You're going to have the whole sales ready to go, and Aunt Betty just threw a bolt into the entire mechanism because, you know what? I want this to happen, or I want my 40 acres, or I don't want to have this sell.
Yeah, that's a signature sheet of multiple landowners on one property right now, and they're in all different states too. Yeah, that's what you run into.
And I'll tell you this, just to piggyback off that for 1 second. The other thing is, I'll hear a lot of little old women, bless their hearts, will say, I'm going to leave it to all the kids together because then they'll have to learn to get along. No, they won't. Right? That's not, if that's our goal, this is not how we accomplish it. And 9 times out of 10, right? The mom is the glue that's held everything together. And when she's gone, it's not getting better, it's getting worse.
Yeah, no, that's so true. And I think, we hadn't really talked about it a whole lot. You did mention muniment of title. I know it's not the end of the world. Now I will say, I mentioned one earlier before we hopped on about a gentleman that they did not probate the will, and he had absolutely no idea that meant that they would end up having to get an affidavit of heirship on him and his son. And then his son ended up having to come to closing to sign for his ranch to sell because the wife, they didn't probate the will. He had no idea. So we ended up having to get an affidavit of heirship. And for those of y'all that don't know what that is, it's basically a form, notarized document that says, I knew that guy's wife before she passed away. We are not related. I was a friend. They are who they say they are. And I don't think title companies love those, but we certainly have to do them sometimes.
Well, that's what I was going to say. Is there are a handful of, I would call them alternatives to probate. Things like an affidavit of heirship, a muniment of title, a small estate affidavit. If somebody dies and they don't have a ton of things to deal with, you may be able to do one of these cheaper alternatives to probate. That shouldn't probably be your plan going in, right? The plan going in should be, let's have a will, let's have this all ironed out. There may be some alternatives, but the point you made, I think, is right, Wayne, because there are some entities that are going to accept something like an affidavit of heirship. Some may not. And so it may depend on the title company you're working with or the financial institution that you're working with as to whether or not they're going to accept that. And so again, I just don't feel like that's ever going to be plan A for folks, right? There are probably better options while someone's still alive. Once someone's passed away and we're stuck with what we have, that's where you can look at those alternatives.
Yeah, for sure. I definitely wouldn't want to go there. We hadn't really mentioned too much about, well, what if, because I'm dealing with one right now and I don't understand this. I don't know how this works really. And I haven't asked the attorney in detail exactly what it is, but we're dealing with the estate. Turns out this guy owned land, owned mineral rights, had absolutely no idea where any family was whatsoever. So I guess he was doing some sort of a pauper's grave for the county or something of that, like a free service to help deal with this guy's estate and get him buried and whatever. I think he was just trying to be a nice guy for this unknown dude that died, we thought, with no family. And it turned out he had a ranch and mineral rights and stuff. And so now we're dealing with that. Well, they did have to track down family and they're in another state. And now we've got two administrators in the estate, or executors, whatever you want to call them. And they're tied to different lineages. Now they have their own attorneys, plus his attorney that's representing his estate. And it takes us forever to get anything done. Now, I know that's a weird one. I think the guy was sort of a hermit. Like, we're working through this, and it's one of those deals where you like hear about the rich uncle.
Right.
It's kind of like, hey, I didn't even know I had that. But once they found out there's money in there, all of a sudden they got an attorney and they're real interested now.
Right.
And so it's become a lot more complicated than I ever would have imagined, because now I say this to people all the time, and it's kind of sad in real estate, but when people get something that they didn't invest a dime in, they seem to want to milk it for the most money I've ever seen. It's wild how the greed can come out in that situation.
Yeah, for sure.
Which, I mean, I've never had a rich uncle that just left me something that I didn't know existed. Maybe I would do that too. I don't know.
Right.
So I wanted to ask, what's the process and how difficult is it to contest a will?
So again, it can differ by state, right? So state by state laws are different.
Yes, there are always that. Let's go Texas. We'll just give you Texas, and we'll
always my answer.
Let everybody guess the rest.
Yeah. On contesting a will, there's a couple of ways that commonly happens, right? One of them is you might argue that the person didn't have capacity to make the will. So like if you've got somebody who is losing their mental faculties, if maybe they didn't understand what they were doing, things like that. So you could have that kind of will contest. Sometimes you'll see a will contested on undue influence grounds. That's where the kid was taking care of them, and all of a sudden while grandma's in the hospital and super sick, she changes the will and leaves everything to that kid, right? Maybe that's valid, maybe that's not, but you got to look at undue influence. There could be challenges just to the execution of the will, right? Did they have the witnesses? Did they actually sign it? Did someone forge the signature? So it depends on the facts. Those are kind of common will contests that we see. And like I say, varying degrees of success, just depending on the facts surrounding the will.
Okay. And I mean, is it fairly unassailable, or it can always be done, right? Like you can always go through the court battle and see what kind of things you can.
Sure. I mean, yeah, listen, the beauty of America, right? Anybody can sue anybody. So that's kind of fact. Now, I would say if a will is validly executed, right? We don't have any issues with the execution. We don't have any issues with grandma being, of sound mind and knowing what she was doing. If you've got a valid will under normal circumstances, those are pretty easy to have held up in court.
Gotcha. Okay.
And
Wayne, I was going to say, Wayne, you look like you're about to ask a question. Jump in there.
Well, I was just to break down the process for somebody, because I've never actually been through probate. I've walked with clients through the process, so to speak, but I'm on the outside looking in. So for somebody that doesn't know, but they're listening and they're like, well, how would I even go about quote probating? So let's say I have a will and I leave out everything as how I want it directed. And the ranch is going to go here. And, this is going to go here and my son will get this, all these things. So we lay it out and then I pass and my wife has that. So they would, I guess, have to go. Do you go directly to a court or do you just go get a probate attorney? How does that process go to get it from now I am taking over the estate and we're legally deeding the properties and doing all of this?
Sure. So what you would have to do is you would actually go in and file a probate. You could do that yourself, or you could use a probate attorney, probably depending on the complexity, right? And how much maybe familiar you are with it, how comfortable you are with doing it on your own. But what you do is you'd file a probate action, and there's some waiting periods and stuff. Once you file, you'll actually introduce the will. The court at that point there's a time period where anybody that wants to contest the will can contest it. There's a time period where anybody who's got debts against the estate, right, if they have claims against them, they can file those. During that time, what the court will do is they'll appoint an executor of the estate. Typically speaking, your will would have that named in there, right? That's the person who's going to act on behalf of the estate. The court would issue what's called letters testamentary, and that lets that executor act on behalf of the estate. And so once we get through all these hoops, and there's different things they have to do, they have to do an inventory, there's different reports, things like that. But eventually in the process, once kind of all the boxes are checked, that executor would be the one who could actually sign over that property from the estate to the new owner.
And an executor doesn't have to be your high school best friend or something like that. It can be an impartial attorney's office kind of thing, to where it's just, they're just going to do what the will says, right?
That's right. And I always tell people, think really hard about who you appoint as your executor, because listen, getting appointed as an executor is not winning the lottery, right? Like, this is not a fun job. You have just won an assignment. Okay. And so, yeah, it doesn't have to be, that has to be your spouse, doesn't have to be your kid. That, if they're, like you said, you could use an attorney to do it. You could use a friend to do it, whatever it is. But just think through who you're going to saddle with that burden, because it is not a fun project to have to undertake.
I was just going to say, my wife and I are just going through this stuff with, we're building out the estate and everything and figuring out, what goes to kids and everything. And we were talking about the executor, and it's like, and it was one of those like, well, who do we want to appoint? And I started cracking up. I was like, who do we really hate? Like, who would I love to just saddle with this awful job that gets to argue between everybody that's left?
Right.
And then that was resulted in us looking across the table at the attorney we were working with and being like, you're
it. Yeah.
Be like, we're gonna leave you the garbage pail kids in my attic for doing this.
Yes.
Right.
Yes. Exactly that.
I mean, that can be a really complicated process, and I just wanted to bring this one up too, because it's not a farm and ranch thing. It could be. I've run into it where there is a property on a farm or a ranch. There's 7 siblings in this particular instance. They did probate. She is the executor of the estate. And the youngest sibling, who is she's older than me, still lives in the house, had stayed with mom all the way until she died. Never had a job. Like the movie Failure to Launch, kind of. And they're going to have to physically remove her. And of course, all the other siblings are like, hey, you're in charge of all this, and it's like, what a horrible position to be put in, to have to be like, hey, there's some money in it for you, but you got to go so we can sell this house too. Because they had land, they had a lot of assets, and they had an old inventory of things to liquidate and split up. And yeah, hadn't been easy on her at all.
Yeah.
So somebody is going through this, right? Maybe we've stoked the fire with somebody to realize that they need to absolutely set up their succession in writing. One, you mentioned something that Texas has. You can just write something out by hand, and that holds up. How often do we see the online form? I found this form online and I filled it out. Do those hold up? Are those is that one of those no, you shouldn't have done that?
Yeah, I hate the online forms for a couple of reasons. One of them is, a lot of times they'll say oh, this is in accordance with Texas law. It may or may not be, right? Because it's like a form bank online. And so you see cases where like this was done wrong, or this isn't how it works in Texas. So I think there's some concern about, are they legally valid in the state you're in? The other thing, again, for the clientele I work with, those forms are done for like grandma who lives in town with a car and a bank account and a house. My folks own ranches and farms and land and equipment and all this. And so that form was never intended for our situation, right? And so I tell people all the time, by virtue of being involved in agriculture, you have a complicated estate. That form is not designed for what you're trying to do. So I really do encourage people. There are things in the law I think you can do yourself. You can do your own power of attorney. You can do your own advance directive, right? I'll give you a list of those. I would pay the money to have a lawyer draft up a will. I think it's too important. You don't want to have trouble. You don't want to leave an opening for a contested situation down the road. I would hire a lawyer in your jurisdiction to draft up a will.
Yeah, and you're right on the farm and ranch side, especially a farm, when you've got all the machinery could be worth a fortune.
Yes.
And then if you've got irrigated fields and you've got all the irrigation equipment and holy moly, and then if you've got livestock and
it's just that's not what those forms are designed for. Like those people know nothing about our industry. And so it's crazy to me that we would let them like dictate what the future looks like. You know what I mean? So I would use a lawyer, and I would find one that understands agriculture and does estate planning.
Well, Mac is pretty good with AI. Mac could probably be like, if you're a lawyer in Texas, draw me a will for a farmer or a rancher.
So I'll tell you, we just did an article about this, and we had AI draft a will. Like me and my co-author, he was like, I'm going to have AI draft a will. I think he gave it like a C. So it wasn't terrible, but we thought that you could have better luck if you use an actual lawyer in Texas.
I'm definitely not promoting AI for anybody listening. That's a joke.
Right. But we did like, well, let's see what it does.
I mean, you say that about your coworker doing that, and I'm like, what was his prompt?
I know. He's like, I should have written that down. We didn't know exactly what he said. Yeah.
I don't know whether AI can do it because I didn't see your prompt.
Right. Yeah. Well, maybe he could have got better than a C if his prompt was better, right?
That's what I'm kind of thinking. I'm kind of wondering if we could have pulled that into B+ territory. I think it's possible.
That's right.
Something to think about with AI, though. There's a lot of crazy stuff going on in that world.
There very much so, and I think the things that we're talking about right now are going to come into play. Real estate contracts, all those things. That's a whole different conversation. I think the AI those places are such low hanging fruit for something like AI. It's not if, but when.
I'll tell you from the legal perspective, there have been some cases, like there have been lawyers who have gotten sanctioned for using AI to write a brief, and it cited a bunch of cases that didn't exist.
They hallucinate. Yeah, if you don't track them,
they're fake.
If you don't track AI hallucinations and you're not double checking it, you're setting yourself up for something very bad.
Absolutely.
And I know Texas isn't the only state experiencing this, but title fraud, especially on vacant property land, is where we're going to see the most of that happen. And I've had some not so up and up people come to me that I know they didn't own the land because the owners were dead. I had to do some digging to figure it out, but I mean, there was tip-offs to that. But I think they're actually addressing that maybe in the special session here in Texas now on the title fraud stuff, if I remember right.
Interesting.
So, there'll be a lot more of that coming along too.
I was going to say, so as far as somebody kind of like, going through this, one, you could just write it out on a piece of paper and maybe hold up, maybe not. Your family might fight for the next 30 years. Mm-hmm. You can get an online form where you can have the same. But Tiffany, tell us that, like, it's pretty basic, but like, tell us the types of people that you want to find and work with. And I don't want to put you on the spot for cost, but if there is a range that you know of that people likely pay for wills, sort of what we're looking at.
Yeah. And it really, the cost is just so dependent on where you are, what the market's like, how complex your estate is. So I really can't give you a good range on that. But I'll tell you what, when you go to a lawyer, that's a question you can ask up front, right? Like, we're looking for an estate plan. Here's what we're thinking. Here's what our assets are. And they can ballpark that cost for you. So that shouldn't be something that's going to like shock you on the back end.
They know what that is up front. It's not like a litigation trial. They know what it's going to be.
And some lawyers will do about an hour, some do a flat fee. So that, it just depends. Estate planning is a little bit different than like a litigation matter. So yeah, I would say ask lawyers up front. As far as what kind of lawyer you're looking for, I think the most important thing with a lawyer is find somebody who you can communicate with, right? If you have a good rapport with them, if you guys can communicate well, again, I always think it's useful if you're dealing with ag stuff to use somebody who's got some ag background. I don't want to have to explain, that the stripper baler is worth $750,000, Wayne, and they're like, what are you talking about, right? Like, so I think some ag background can be really helpful. And then you want somebody who's practiced in this area, right? If you need an estate planning attorney, that's great. I would probably call somebody different if I had some sort of like real technical environmental permitting issue with, regards to my packing plant, right? So I would find somebody who works in that area you can communicate with. If you're an ag, has some ag background, that's what you're looking for.
Yeah. On that note, I will say pretty much any real estate person that works land, I can think I can name probably 5 right now in this local region.
Yeah.
That specialize in estate planning and some that are better in the land matter. It's kind of just like you were talking about. We've talked about, solar on here before, but I have solar attorneys that I know are excellent at dealing in solar and wind or oil and gas. So yeah, I definitely, and I think if you ask around, you definitely could find someone that specializes in estate type planning and
I really do think word of mouth is the best way to find somebody. I mean, I'm a big believer in, especially because a lot of your friends hopefully have already done this, right? So ask around, who they use, did they like them? If they've lost someone, have they been through the probate process with a lawyer? I think word of mouth is the best way to find somebody good in your area.
For sure.
Agreed. As far as, I feel like we've covered most of the things, but are there any, and I guess more of a question for Tiffany, are there any resistance points where people don't want to do this stuff that that you hear that we haven't covered?
I think we've hit the big stuff. The one thing I will say is I'll hear sometimes people will say like, oh my gosh, well, we have to avoid probate. We have to avoid probate. Again, depending on the state you're in, that might be true. There are some states, Texas is an example, where you could spend more money and effort and headache trying to avoid probate than just probating the will, right? So I would just say, talk to the lawyers, know what your options are, know why you're doing what you're doing. If they're telling you to do something, know why, right? They want you to set up a trust, that's fine, but just make sure you understand the purpose of that. So that's the one encouragement I would give, but I think we've hit on the big issues beyond that.
Yeah. And Tiffany hit on a good point early on. I will say this is probably the least exciting topic I think I've ever wanted to discuss on here, but it carries the most weight from an importance standpoint. So I had way more fun talking about easements. That stuff's so fun, but the probate end, so the cost, you're going to save a lot of money by dealing with it up front. When someone comes to me and they want to sell something, someone's passed away, they've never probated the will, it's like you almost don't even really own it.
Yeah.
Like it's what gives you the authority if you've never legally taken the other half of that ownership and put it in your name? And so you've got a quagmire, and it was just like what we were talking about where I had the buyer on a deal recently. We terminated it a week or two ago, and the seller on that land had never probated, and then found out as we were trying to clear title on that a stepson in another state was going to get the money, and she did not want that and decided she would probate. Now there's time limits in Texas, I think, on how soon you could probate after death.
Yeah.
I don't know what that is, but she was within the time. And so we went ahead and terminated because it could take a while.
Yeah, it can. And like I said, there are limits on how long you have. I think it's 4 years. Typically there can be exceptions to that, but I mean, it's a pretty long time. You don't have to do it, the day after someone dies, but you also don't want to wait around forever. Like we talked about, that only makes everything get more complicated as time goes on.
Yeah. So as far as vital importance, like Max said early on, there's so much land that's changing hands right now, and it's going to be going on to these younger generations, and a lot of them don't want to keep it. There's going to be a lot of selling going on, and you really need to handle that if you want to do yourself and your family a favor. and taking care of that up front. As unfun as it is to discuss, and I will admit that I don't want to talk about it, but it needs to be done. You're costing yourself in the long run big time.
Well, I think the important thing to know too is like you're costing your family. Like there will be conflict if that stuff's not set into place. It's unavoidable. I had the deep dive because I couldn't remember the name of the ruler. It was Diocletian, right, of the Roman Empire. So Rome was established in 750 BC. It goes for nearly 1,000 years. And toward the very end, you have an emperor named Diocletian, and he decides he's going to leave 4 heirs, and they're going to work it out. The Roman Empire was collapsed in 170 years later. And in the midst of these 4 people fighting it out, people dying, people killing each other, and fighting over territories and breaking up the Roman landscape, this empire that lasted almost 1,000 years got left because the guy didn't have a will.
Yeah.
So that was something I wanted to leave this on. I had to look. I had to make sure I had the years straight. It was look that one up because that's what happens.
Yeah.
The fall of an empire. That you should just title this that. how to protect your empire, something along that lines.
Well, I'm not going to do that. Okay. I don't know how many fuzzy details I just threw out. I'm going to rely on the listener to go out and check me on that because I got to have some wiggle room.
You get that from AI? Did AI give you that information?
No. I had to pull that from the memory bank, but they didn't directly cause the fall. But I'm just going to say correlation is not causation, but we're close enough on the timeline to say that there's something there.
Mm-hmm. Mm-hmm.
That's funny. Your brain works on a totally different level than mine, Mac. I love that about you. He's creative. I'm just boring.
Wayne's trying to say I'm weird, and it's okay. I'm weird. Awesome. Well, Tiffany, I want to be respectful of your time. Thank you so much for taking some of that and giving some of that to us today.
Sure.
It's invaluable, and this topic is invaluable. It doesn't get addressed enough. And Wayne, thank you for bringing this to the table. This is very, very cool. It's great having you both. I'll have both your links in the show notes. So thank you very, very, very much.
Awesome. I appreciate it. I always enjoy it.
I jumped in.
This concludes episode number 153 for the National Land Podcast, discussing probate with National Land Realty agent Wayne Dunson out of West Texas and Texas A&M University professor Tiffany Lashmet. You can learn more about land ownership and the buying and selling of land at nationalland.com. And do not forget, save this podcast to your favorites, subscribe, and review this podcast so other people know how good it is. We'll see you next time, and thank you.